Sadly, we were unable to settle your case following the pre-litigation negotiations. So now we are moving forward into what's called litigation. This is, as you've seen on movies and in TV, where we will be in front of the court trying to effectively go to trial at the very end of it to make sure that we have a jury making the decision of what your case's value is, as well as finding the other side liable for your injuries and the accident. The first step of that, though, is called the complaint. And the complaint stage of your case is where we are drafting up a formal complaint, formal pleading to the court, going over what happened, the facts of the incident, how that was a breach of a duty of care, and how that caused your injuries and what damages or injuries you suffered as a result of the other party's actions. We will name out every single party that possibly could be at fault for causing your injury. Now, if this is an auto accident, that's going to be the other driver, potentially the owner of the vehicle. If this is slip and fall, the owner of the property or the company that may have caused the dangerous condition on the property. And in medical malpractice, otherwise that can be your doctors, the nurses, everybody that was seeing you during that time. Once the complaint has been drafted by the staff, you will meet with the attorney to go over the complaint's facts to make sure that that is correct, everything that's stated in there, because these are your words. We also will go over the different damages we will seek in this case, as well as the different claims overall. We will file the complaint to proceed forward with starting the case and setting it up for a jury trial. Once the case has been filed, then we'll go to the next step, which is service. Here, we will serve the complaint as well as some other documents to the at-fault people, the defendants in this case. Service generally will require us hiring a company to go out and be a service processor. They will provide the documents, including the complaint, and personally serve them to make sure that they are aware of the lawsuit against them. Once service has been completed, and just to let you know, service can take some time. It may take 90 days for it to complete because the defendant might be trying to avoid service, which is sadly a very common process by a lot of defendants. People do not want to take ownership for the injuries that they've caused. However, once service has been completed, we'll go to the next step, which is the filing of the answer by the defendants, as well as moving into discovery. Now, the answer is where the other side answers your complaint, your alleged facts, injuries, damages. This will generally be done by an attorney through the insurance company, and they are going to deny everything. That's just the way it is. They are never going to omit anything that might be used against them at this stage. The main part of this, though, is we go into the discovery stage. Now, discovery is where we are able to discover evidence, be able to learn what the other side is going to claim, both in terms of story as to what happened, how your injuries were maybe not caused by the accident, as well as any defense they have to your case. But they will also be able to do the same to you. Learn what facts that happened, be able to ask you why, how you're injured, if you had any prior injuries, anything to that extent. With discovery, there's a couple components, main components. The first is what we call interrogatories. These are written questions to a party that you will have to answer with your attorney, going over facts in response to the questions. That could be your pre-existing injuries you may have had, how the accident happened, what did you do after the accident, did you make any statements. You'll be working with the attorney and paralegal to answer, and we'll do a meeting with the attorney to go over. The next one is a request for production. This means to produce documents, requesting to produce documents overall. Here, we will ask the other side, please produce your insurance policies, please produce any photographs of the vehicle or of our clients in the accident. Please produce any videos, please produce any type of document that might be used in this case. We also will do requests for admissions. These are admit or deny a fact as we allege it. Finally, we also will do depositions. Now, these are where you get to be interrogated by the other side, but we also get to interrogate the other at-fault party. In the discovery stage, another thing that's going to happen is the hiring of expert witnesses. Now, these are specialists who have been hired. They could be medical doctors, accident reconstructionists, people to go over the physics of an accident, how it might affect you, to go over and provide an opinion that might be used in court. At all times in the discovery phase, we are looking at what we need, what's going to happen at trial. What's the testimony going to be? what's going to be presented, and effectively what is the story of the other side, and what our story is going to be. During this phase, it can take a long time. This is generally the longest part of your case. It can take up to a year plus on medical malpractice cases during this phase. There might be a lot of fights going on, but you will be working with your attorney and we will keep you updated. However, please know that if we are going in litigation and during this phase, it does take a lot of time. And that's just sadly the fact for every single case. Once this discovery phase has been completed, we'll go into the next stage, which is mediation. Mediation is where you will be having a third-party attorney effectively acting as a judge, hearing both sides, both our side as the injured party, as well as the defendant's side, saying how they don't believe that they're at fault for certain things or their evaluation of the case. This will generally take place over a full day where you will be with your attorney in a mediator's office or via Zoom and going over trying to resolve the case as the mediator is trying to find a happy compromise for both sides. And I say happy compromise because at the end of the day, he's looking to try to make sure that we come to a resolution without having to go to trial, because trial does have a lot of risk. Because at the end, if mediation is not successful, generally that's the next step, is going to trial. During this time, the mediator will be able to talk directly to you with your attorney, and we may settle the case, but it may take a couple of days afterwards to be completed. I will say a majority of lawsuits are settled in this mediation phase. Otherwise, we will go to trial, where, as you've seen on TV, where we will go in front of a jury of 6 to 12 people who will hear both sides and come to a decision on the case.